Good evening, everyone. It's 6 o'clock. We're going to go ahead and start tonight's meeting. Let's go ahead and begin with a roll, please.
Commissioner Lydé.
Here.
Commissioner Calandra. Here. Commissioner Diaz.
Here.
Commissioner Kreiner. Commissioner Shergill. Vice Chair Bray.
Here.
Chair Vang.
Here. Everyone, please stand. We're going to start with the Pledge of Allegiance. Ready? Begin. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible. It's amazing how we still remember that, huh? I'll go ahead and read the procedures for tonight's meeting. This meeting is being conducted in person and electronically. For each matter considered by the Commission, there will first be a staff presentation, followed by a presentation from the project applicant. Testimony from supporters of the project will then be taken, followed by testimony from those in opposition. The applicant will have the right to a final rebuttal presentation prior to closing the public hearing. In accordance with Section 13 of Article 2 of the Planning Commission Rules and Regulations governing length of public debate, all public testimony from those in support and opposition of the project will be limited to 3 minutes per person. The 3 lights on the podium next to the microphone will indicate the amount of time remaining for the speaker. The green light will be turned on when the speaker begins. The yellow light will come on with the soft bell ring when 1 minute is remaining. The speaker should be completing the testimony by the time the red light comes on with the final bell indicating time has expired. All in-person public testimony must be presented to the Commission at the podium. Any testimony that references race, religion, ethnicity, economic status, national origin, or any other classification protected under state or federal law in a derogatory manner shall be deemed irrelevant and will not be considered by the Commission in making its land use determinations. If you challenge these land use matters in court, you may be limited to raising only those issues you or someone else raised in oral or written testimony or before the close of the hearing. Do we have any changes to the agenda?
Good evening, Chair Vang, members of the Planning Commission. I'm Israel Trejo with the Planning and Development Department. There are no changes to the agenda. Thank you.
All right, thank you, sir. Do we have any commissioners who have any changes or a motion to approve the agenda?
I'll move to approve the agenda. Second.
All right. We have a motion made by Vice Chair Bray, a second by Commissioner Calandra. All in favor say aye.
Aye.
Aye. All opposed say no. Motion's approved. Under the consent calendar, we do have one item here for tentative track map number 6172. Do we have any comments, questions from the Commission, or any motions from the Commission?
I'll move to accept the consent calendar.
We have a motion made by Vice Chair Bray, a second by Commissioner Calandra. All in favor, say aye. 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 All opposed, say no. Consent calendar is approved. Do we have any reports from the Commission? I see none. There's an item on here under new matters, but that one will be pushed to January 15, 2025. So next we have a workshop for the Planning Commission. Planning Commission 101, overview of findings and requirements. And we have to make sure we pay attention now. There will be a quiz after this too. So.
We already heard about that.
Good evening, Commissioners. Tonight we have a presentation on Planning Commission 101, which is just going to give a broad overview of the role of Planning Commission within the City of Fresno, the types of decisions that Planning Commission will be called upon to make, and required findings which underlie some permits, as well as how to understand these findings. So to begin with, what is a Planning Commission? A Planning Commission is a committee appointed by the governing body of a municipality. They review and act upon matters related to planning and development within the municipality, and that would be you, of course. The governing body here would be City Council. Generally speaking, Planning Commission, your role is, the powers of your role are set out by the city charter as well as section 15-4903 of the Fresno Municipal Code. So why do we plan? Planning allows a municipality to proactively establish goals and policies for directing and managing growth and development within their jurisdiction, including the locations of specific types of growth, housing needs for the jurisdiction, and environmental protection of the region. Generally speaking, development will then occur in compliance with the various types of plans applicable to the site. For example, the general plan for the city and specific plans that apply to the site, the development code, and other provisions of city law which are applicable to the development at issue. The duties of Planning Commission include that you serve as an advisory board to the City Council on planning and development issues. You hear and decide appeals from decisions where the Director of Planning and Development is the original review authority. You also serve as the original decision-making body for some types of applications, such as tentative tract maps. And of note here is that your decisions on original review authority applications and where you are the appeal body are appealable up to City Council by the mayor or by the council member in whose district the development lies. This also applies, not only when you are the original review authority, but also when you are the appeal authority.
My apologies. Let's please note that we have Commissioner Shergill. He's present.
All right, so the types of decisions that you will be called upon to make, which might come to you for review, include, and we will go into more detail in subsequent slides, but just briefly, the first type is a ministerial decision. These are mandatory decisions which might come before you for review, but are very likely not to be seen. They're very rarely seen by this body. The next type is legislative. In this and quasi-judicial decisions, my apologies, both of these decisions are discretionary in nature and are far more commonly reviewed by you. With regard to legislative decisions in particular, you act as an advisory recommendation body to the City Council, which holds the ultimate authority on those decisions. With regard to quasi-judicial decisions, those are very commonly seen by this body, and they are seen, as discussed earlier, in the form of applications which come to you for review or appeals. So getting into the details of ministerial decisions, these types of decisions are non-discretionary in nature. So what that means is if the information provided by the applicant in the application packet meets all the requirements for the permit type, then it must be approved by staff. They cannot deny it. They have no discretion to do that. If the information provided by the applicant in the application packet does not meet the requirements for the permit type, then they must deny the application. They don't have discretion. Planning Commission is unlikely to review these types of decisions unless it comes to Planning Commission on appeal, but that's also rare. Examples of those types of decisions include final subdivision map approvals, building permits, and zone clearances. Moving on to legislative decisions. These types of decisions are discretionary in nature. They involve policy decisions and can affect broad classes of current and future landowners. Examples here include amendments to the general and specific plans. This includes both periodic full updates of the plans or adoptions of the plans, as well as minor amendments that occur along the way, such as changes to the land use designations for a specific parcel. This also includes, legislative decisions also include text amendments to the development code. This can include broader changes to the operation of the city's permitting processes, such as the Responsible Neighborhood Market Act, which passed a few years back, or more minor changes, such as changing the word "and" to "or," which would affect the applicability of a section. You would also see rezones, which is, it affects the zoning for specific parcels. In this instance, when we're talking about legislative decisions, this is where PC acts, or Planning Commission, excuse me, acts only as a recommendation body. So you will review it, take in public comment, consider it, and then make a recommendation to City Council, which will make the ultimate decision here. With regard to quasi-judicial decisions, they are also discretionary. In considering quasi-judicial decisions, the decision-making body is meant to act as a neutral decision-maker, similar to the way a judge makes decisions, hence the name quasi-judicial. Decision-makers here must make their decisions based only on the evidence provided on the record. So nothing that comes out of, opinion articles or discussions outside of the hearing or the evidence provided to you. In these decisions, what the decision-making body needs to do, if Planning Commission is that decision-making body, or any decision-making body such as City Council, you have to apply the standards and requirements of the city, primarily those come through way of the development code, to the facts of the application to make specific findings. Procedural due process requirements do apply here, which is very important to note. What that means is that we need to provide notice and a hearing, a public hearing where public can come attend and provide comment on the project. Most commonly, you're going to see these via appeal, but as I stated before, you might have some instances in which a conditional use permit, you are the original review authority, for example. Not always, by the way, just to note. There are very rare instances where that's the case. Types of entitlements, which are considered quasi-judicial, include a variance, and just briefly, a variance is where an applicant is requesting to be permitted to build a project which deviates from the standards of the development code. You'll also see development permits, conditional use permits, plan development permits, and tentative maps. And all of that leads us into, there's a bit of just a visual on how to understand that, applying the facts of the development code to the facts of the application to make specific findings. All of that leads us into understanding findings themselves. So what are findings? Put simply, findings are explanations of why legally and factually the Planning Commission makes a particular decision on a matter. They show how the decision maker applied the evidence available to them to reach their final conclusion or decision on the matter. Put another way, like in math class, you have to show your work. Findings are always required for quasi-judicial matters, and they might be required for some legislative decisions as well, but you'll see that when they come to you. Findings must be supported by substantial evidence in the record. What does the record mean? The record includes the application materials. They also include correspondences between city staff and the applicant. They include the staff report that you are provided ahead of the meeting. They also include technical studies and consultant reports, such as noise or traffic studies. They include the comments received from the public during the hearing. They also include written testimony, which the city receives ahead of the hearing, such as letters or comments received in support or opposition of the project. And they also include the general and specific plans. So some examples of some of the types of permits that have findings like these attached to them include conditional use permits. These are more commonly seen on appeal by Planning Commission. You might see them as review authority, but as stated, it's very common on appeal. The findings here require that the conditional use permit shall only be granted if the decision maker determines that the project as submitted or as modified conforms to all of the following criteria. If the decision maker determines that it is not possible to make all of the required findings, the application shall be denied. The findings are that the proposed use is allowed within the applicable zoning district and complies with all other applicable provisions of this code. When they say code, they're referring to the development code specifically, as well as all other chapters of the municipal code. Also, the proposed use must be consistent with the general plan and any other applicable plan and design guideline the city has adopted. The proposed use will not be substantially adverse to the public health, safety, or general welfare of the community, nor be detrimental to surrounding properties or improvements. The design, location, size, and operating characteristics of the proposed activity are compatible with the existing and reasonably foreseeable future land uses in the vicinity. The site is physically suitable for the type, density, and intensity of use being proposed, including access, emergency access, utilities, and services required, and the proposed use is consistent with the Fresno County Airport Land Use Compatibility Plan. The other type of permit you will most commonly see is development permits, which also have findings attached to them. The findings for development permits require that the director or planning commission may only approve a development permit application if it finds that the application is consistent with the purposes of this article, meaning the article in which this code section is found, and with the following: the applicable standards and requirements of this code, meaning the development code, the general plan and any operative plan or policies the city has adopted, any applicable design guidelines adopted by the city council, any approved tentative map, conditional use permit, variance, or other planning or zoning approval that the project required, and the Fresno County Airport Land Use Compatibility Plan. Really quickly, I don't have a slide for this, but I did want to touch on conditions of approval, just so that those can be understood a little bit better as well. Conditions of approval are generally imposed on applications where the conditions are reasonably related to the application and are deemed necessary to achieve the purposes of this article and ensure compliance with the applicable criteria and standards established by the development code or mitigation required pursuant to environmental review. Conditions usually are attached, they actually have to be attached to a specific finding required under the permit. You may end up hearing the terms nexus and proportionality at some point. What that means is that the conditions must be related to a direct effect of the project, which is the nexus, and must be no greater in scope than the effect to which they are related, which is proportionality. You will usually see these conditions as part of the packet you receive on development projects ahead of the meeting. This is an example of what the findings section in the staff report looks like. Usually it's shown as an exhibit to the staff report, so you'll see a brief summation that staff felt the findings could be made, and then they'll point to the exhibit where you can read further. This is an example of what the findings document itself will look like. In summation, the best practices here are to be prepared as much as you can for the meeting. I know that you do sometimes receive large packets of documents for review, but it is best, to the best of your ability, to prepare ahead of time for the meeting by reviewing those packets provided to you. In particular, familiarizing yourself with the required findings before the Planning Commission meeting can help give you a basis of the types of decisions that you're having to make at the meeting the following week. And it's also best to review the evidence which is made available to you and any objections which might come up. Of course, you also need to take into consideration any public comment received during the hearing. And that is the end of my presentation, and I am available for questions.
Thank you. Thank you for the presentation. Do we have any questions or comments? Thank you. Appreciate it. Do we have any reports from the Secretary?
Just briefly, thank you, Heather, very much for your presentation. You know, Heather's role as counsel to the Planning Commission is obviously crucial to the legal underpinnings of your decisions. So, you know, she is here to assist us in making those decisions and determining whether or not there is enough evidence in the record for us to make a determination for the commission to add conditions to a project. So I would encourage you to review As Heather said, the findings that are in each particular application when they come up, to make sure that you have identified in your review, your independent review of an application or of the packet that you receive, that there's enough evidence in the record for you to make each one of those findings. Because as Heather said, in a quasi-judicial matter, you're acting as a panel of independent judges based on the evidence in the record that was provided ahead of the hearing in the form of the packet, as well as at the hearing in the form of testimony. So, you know, it's such a crucial role to the city, and we appreciate everything that you all do. It is not an easy job. It is a hard job, especially when you have to have that independent decision-making role when there may be people in the audience that you know personally, when there may be comments that have been made that have, you know, triggered in some way an emotion. So we really do understand that you have a very difficult role, and we really do appreciate it very much. So I wanted to take this time to say thank you to each one of you for everything you do. It's the end of the year. It's our last meeting. We won't see you again until January 15th. We hope that you have a very happy and healthy and safe holiday season, new year, and come back invigorated and ready to go with a full slate of projects for next year. So thank you very much for your time, and to Heather for your expertise here, and to our staff for everything that they do. They work really, really hard. Carrie in the pit, and Israel and Ashley, and their teams who work to make sure that they get you as much information as they can at each meeting. So thank you again for your service.
Thank you. Do we have any unscheduled or communications? I see none. 6:23, meeting is adjourned.